So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about this newest letter from the Office of the General Counsel of the National Labor Relations Board. Her name is Jennifer Abruzzo. This is Memorandum GC 2308. And it came out 2 days ago or 3 days ago. And it's something that's been expected, maybe long awaited. And it's the non-compete agreement ban from the National Labor Relations Board. So the subject of the line, which is most important, is non-compete agreements violate the National Labor Relations Act. And it first starts that, many employers require their employees to sign non-compete agreements to obtain or keep their jobs or as part of severance agreements. I mean, that's, obviously true, although I think that the non-compete agreements are dying out and have been for a long time. Quite often they're very unenforceable. You can't really do a whole lot with them. And it says that, well, these non-compete agreements between employers and employees prohibit employees from accepting certain types of jobs at the end of their employment. And she explains, Jennifer Abruzzo, the General Counsel, explains that she thinks that it's a violation of Section 7 of the National Labor Relations Act. So Section 7 is is the right to self-organization, form, join, or assist labor organizations to bargain collectively through representatives, et cetera, et cetera. Section 7 has become one of those things sort of similar to the Commerce Act in that it's been twisted and expanded in definition such that it encompasses a lot of things that I'm not sure the initial writers intended. So, for example, you cannot fire someone for discussing their wages because it's a violation of Section 7. The reason it's a violation of Section 7 is it prohibits people from talking about their wages and as a result join labor unions under Section 7. Very odd to me. I understand the reasoning, I suppose, but again, this is a large expansion and not, I think, the intent of the writing of the National Labor Relations Act. It says further that it's a violation of Section 8, which I'm less familiar with. Section 8 is not one that I am familiar with, but it's very clear. It's interfering with restraining or coercing employees in the exercise of their rights guaranteed in Section 7. And so, as a result, they're going to adopt the idea that it's a violation, the non-compete agreements can be a violation of the Section 8 rights if it reasonably tends to chill employees in the exercise of their Section 7 rights. And so, this is a long time coming, in my opinion. So it says that it chills employees from concertedly threatening, non-compete agreements chill employees from concertedly threatening to resign to demand better working conditions. Non-compete agreements, I don't find to be enforced very frequently. I guess this is big enough for the National Labor Relations Board to take on, but I don't see this very often. I don't see anyone carrying out a threat on this, at least. In addition, it stops employees from carrying out concerted threats to resign or otherwise concertedly resigning to secure improved working conditions. I feel like, I feel like that if you wanted to use this argument, you could argue that a well-paying employer would chill employees from carrying out concerted threats to resign as well. And that's where I think that this falls a little bit flat. I think that's sort of an argument there. And that's what it says here. It says it is unlikely an employer's justification would be considered reasonable in common situations where overbroad non-compete provisions are imposed on low-wage or middle-wage workers who lack access to trade secrets or protectable interests. And I agree with that. Like, non-competes for me are really only for high-wage earners who have broad strategic knowledge, not for hourly workers. But I also don't know that they're ever enforced on hourly work. Maybe they are, and I'm just not privy to it, right? This definitely seems to be for me simply discussion or a solution in search of a problem, right? Um, the National Labor Relations Board says that non-compete agreements might necessarily violate, not all non-compete agreements might not necessarily violate the NLRA, agreed, but I think that, again, this will have a chilling effect on any of them. And so it'll be pretty interesting. So what this is doing, what the General Counsel is doing here, Counsel Abruzzo, is asking for the regions of the National Labor Relations Board, to submit cases about this topic, so that the National Labor Relations Board can define and stamp this down. As a result, regions should seek evidence of the impact of overbroad non-compete agreements on employees, and, where applicable, present at trial of any adverse consequences. And so I'll tell you, my problem with this, and it's my problem that I've seen with the National Labor Relations Board overall, is this is activism, right? They're seeking out cases and encouraging people to come forward so that they can put into law, regulation, more regulation or past practice than anything, these cases, and so that they can win. They're setting the rules so that they can set the rules further. I find it so odd. I find it sort of a little gross. If this is the case, if this has a chilling effect, have Congress pass the law, or propose a new regulation, or do anything else other than ask people to come to you. But ultimately, I think that Congress should pass a law. If non-competes are a violation of the National Labor Relations Act, then pass a law to include them in there. But they're not, because this is a sort of abuse of Section 7 rights and Section 8. Let me know what you think in the comments down below. I don't like non-compete agreements. I think that should be clear. I think that they're, generally speaking, at least for middle and low wage workers, unnecessary and not very effective, and are unenforceable in many cases. But for a high wage employer, sure. High wage employees, sure. I just think that this specifically and this activism is not the best thing. Let me know what you think in the comments down below. I'll see you on the next video. Bye, guys.